Or leave to move without certified copy and move today itself because my
What
lord
is
of
the urgency?
demolition. Demolition is I have prayed for an order
Son,
by the municipality. Suit, refuse ad interim order of injunction by which I only prayed for the production that not to be dispossessed, not to do anything without due process of law. What is happening is that, my lord, I am being, my lord, my entry is there with through legal process. Agreement has was executed. It has expired. I am carrying on the business from the particular place, my lord. But my lord, what is being confused?
file it will appear Monday.
My lord, Wednesday they came with the bulldozers. I had moved earlier. Ad interim order, I was not, my lord. Yesterday the order has been passed in the miss appeal. Now I'm before your lordship.
Which municipality?
Vidhannagar municipality, BMC, BMC.
Who is appearing?
My lord, it's without any. There's no caveats, so therefore.
No. Who appears for Vidhannagar municipality?
Mr. Tirthankar De.
Please serve him a copy.
But
Monday.
after my lord, the leave is granted if I file and thereafter, my lord.
Yes, please. Yes, leave is granted. I'm keeping it on Monday. Please.
Monday.
Please serve a copy.
Saturday and Sunday is there, my lord. They are coming with the bulldozers directly and saying that nothing. That is a difficulty. I'll take my chance. If it is, my lord.
Please serve a copy.
I'll serve.
Millard, item number 732, Millard. Millard, the arguments have now been fixed, Millard, on 20th July. But I had mentioned it earlier also.
What is the order under challenge?
Millard, amendment was allowed. There is a direction for expeditious hearing. Millard, thereafter, I have not been given the opportunity to give the additional WS. But fixed for arguments, Millard.
My lord, may I be permitted to mention, my lord, item number 1818 of the monthly list, my lord, from one order dated September 18, 2025, my lord, for early hearing, because, my lord, the division bench has directed us to approach this court, and it is written over in the order that a single judge with to approach with the prayer for early hearing, my lord. My lord, no date be fixed, my lord, because the item is coming up next on 21st July in the contempt court, my lord. One revision has been preferred, one contempt has been preferred, my lord.
Who is appearing for the other side?
Lord, Mr. Oil Dotto.
Have you served the notice upon?
Yes, my lord, the notice has been served.
No,
my lord,
mentioning.
My lord, to Rupa, Miss Rupa Singh, my lord. Yes, my lord.
Upon notice.
Yes, my lord. The mentioning notice is there, my lord.
All right. Yes.
Permit to mention for upgradation in the daily list.
My lord, may a date be fixed, my lord, before 21st July?
My lord, may I permit to mention new motion.
Yes.
Your Lordship, may I be permitted to mention a matter was being filed on 7th of January.
What do you want? Upgradation?
No, my Lord, that was in the list of monthly and 729, and the 13th of July is the next date, and the learned court asked for where. Otherwise, the our
what is the impugned order?
My impugned list order condition.
Your Lordship, may I be permitted to mention a matter, my Lord? My Lord, I am seeking for upgradation of item number 535, Your Lordship, of Your Lordship. Upgradation. My Lord, due to...
My Lord, actually many dates have already been given in this matter.
Early hearing of the matter, my Lord, there is a check that has been given under an agreement, which was entered into when I was in jail, my Lord. My Lord, that check is maturing on the 20th of July, Your Lordship. That is why I am praying that Your Lordship may take it up anytime, my Lord, in the next week or the coming week.
May I mention...
irreparable harm will be caused if this matter is not taken
it's
up.
in the monthly list, my Lord. I want it in the daily list. My Lord, may I be permitted to mention, my Lord, item number 568 of the monthly list, my Lord. My Lord, the urgency is this, my Lord, the 14th July, my Lord, the matter has been fixed, my Lord, for hearing of the section 7.2 of the West Bengal Premises Tenancy Act, my Lord.
What is the order which you are challenging?
My Lord, I am challenging, my Lord, they have not let me to file the application, my Lord. That is the whole...
What application?
My Lord, under section 7.2, I am the tenant, my Lord.
What application they have not allowed? You are saying that 7-2 application is fixed for hearing.
My lord, fixed.
What application they have
My
not
lord,
allowed you to?
before that, my lord, I am seeking. My
What
lord,
application you have not been allowed to file?
my lord, under sections.
Please
My
go
lord,
to the brief.
my lord,
Your Lordship, may I be allowed to
kindly,
mention
my
on
lord, on
matter for
14 July, my lord, the matter has been fixed. My lord,
Sir, you are
before that-
saying 14 July 7-2. Let it be hard. What is the difficulty? What application you have not been allowed to file? That also you cannot say.
Your Lordship,
Yes.
I am mentioning on matter for inclusion, Your Lordship.
Motion.
New motion, Your Lordship. The matter was filed on.
Yes. Call the list.
my lord, may I be permitted to mention a matter under the heading new motion?
Hand over the slip. Yes.
Item number 2, I am appearing for the petition. And this matter has been disposed of on VTA order dated 10th February 2022. Long back, my lord.
It has been disposed of.
Disposed of, my lord.
When it has been disposed of?
10th February 2022, my lord.
It has been assigned on 8th of May 2026.
Long back, it has been disposed of.
You are appealing for the petitioner.
Petitioner, my lord.
All it pass it over. Please go through this. It has been assigned on 8th of May 2026.
Thank you. Much obliged.
Any appeal after appeal, has it been remanded? Please go through the records. Yes. Pass over. Next. It has been
My lord, item number 4, my lord, I am for the petitioner, my lord. Why it has the lordship is probably muted, my lord.
Yes. Call the next matter.
My lord, 4, my lord, I am for the petitioner, my lord.
Yes.
My lord, it has been mentioned, my lord, at my behest, my lord, since Mr. Chakraborty was appearing, my lord, in Baruipur court.
Since I'm not inclined to take up this matter on yes.
Milord, this is the matter where Milord, Order 7, Rule 11 application has gone down because of
Should be dismissal of suit.
yes.
I appear for the opposite part.
Mr. Banerjee, have you recorded in both the orders or in one of the orders?
না না এ হয়েছে যেটা নেই ডিসমিসাল লেখা মানে মিস্টার উপাধ্যায় মিলট আর ওটা কোথায় আছে টাইমটা এটাতেই আছে দেখান
So,
Milord, instead of Milord correcting every line, if Milord just Milord
Yes,
two sentence, Milord kindly direct.
wherever it appears as order 7 rule level, it shall be read as. Mr. Banerjee, learned advocate,
But I am for the predetermined extension of testing.
extension,
Yes.
when it expired.
But it was expired before expiry. It was filed. Not only that, it was before.
Application was filed before expiry.
Yes, not only that, it was mentioned before the honorable court. You can see last order.
Have you served upon the opposite party?
Yeah, appeared, my lord. You can see last order.
No, have you served this application upon the opposite party?
Yes.
Where is the evidence service?
Well, they appeared. You can see the order when the last order passed. I have filed before this court.
No, have you filed any application?
Yes.
What is the number of the application?
Can number 1 of 2026.
Can one of Post off.
7, I am for the petition.
But I am for the opposite party, my lord.
The interim order which has been passed, is valid till Tuesday. I am praying for extension, but the affidavit of service, pursuant to my lord's direction.
Not only one submission, my lord. But Mr.
One, you can make two submissions.
But I am also
But
praying, my lord.
Mr. Mukherjee, my lord, has not been properly instructed. The submissions that have been taken note of from paragraph 2 of the last order, but this is absolutely incorrect, my lord. It's not been properly instructed. My lord,
Absolutely correct, my lord. I have handed
But
over the
it
copy of
says-
the order of the restoration also.
but it says that petitioner went on depositing rents in suit number 163 of 1977.
My lord, there in that suit, a receiver was appointed.
My lord, this is a civil suit. My lord, before the High Court, original site.
Correct.
My lord will kindly see, this suit was dismissed with interim orders being vacated. My lord, at the time of restoration, there was no restoration of the interim orders. The receiver who was appointed, he never became the receiver thereafter.
That, my lord, I shall show
My lord,
for your
those
lordship. Even
extensions were never asked for.
Now, what is the impugned order?
My lord, 7-2 has been disposed of. They did not appear. They did not give any evidence. The previous order by which, my lord, the 7-2, my lord, giving of evidence was closed. That has also not been challenged.
my lord, my lord,
Before your
my lord,
lordship.
should have been, my lord, instructed properly. My lord, that has been challenged. Revisional application, my lord, admitted. Copy has been served. My lord, here the court has erroneously come to a conclusion that all the deposit that have been made pursuant to a direction of this honorable court in a pending suit wherein the receiver was appointed, those deposits are bad deposits since the suit has been dismissed for default. This was not properly, my lord, assisted by the court, since on the very next day of the day of dismissal of the suit got restored. Oh, within 4 days, my lord, I stand corrected, not the next day. Within 4 days from the date of dismissal of the suit. That's where, my lord, the learned, my lord, the coordinate bench of your lordship's court recorded that this prima facie have been shown that this is, my lord, not erroneous deposit before the receiver. একবার দিয়ে impute একটা তো revisionটা দিয়ে একটা।
Since 2018, 7-1 and 7-2 are pending.
Once, my lord, it has been disposed of, thereafter, my lord, civil revision preferred, the matter has been remanded back. Internal page 3 of the order impugned, my lord, the second paragraph of that, my lord, that's the premise on which, my lord, I have been held to be a defaulter. Page 40, my lord.
40.
40.
We ordered the your appointment order.
Mr. Mukherjee, where is your statement that that you are still paying that rent in the 7-2 to the receiver?
After filing of the suit.
No, 7-2, according to you, you are not a defaulter.
Yes, yes.
So where have you stated that you are paying to Mr. X?
Just a minute. Yeah. Paragraph 17, your petitioner, internal page 4 of the application, my lord. Your
Yes.
petitioner states that in terms of the said order dated 7 September 1977, your petitioner tendered the monthly rent in respect of the said month to the such and such, being the receiver of the trust, and your petitioner lastly paid the aforesaid monthly rent on such and such for the month of April 2018 to June 2018, and the said such and such, being a receiver, issues the rent bill in favor of your petitioner. All these, my lord, are with me.
Yes, till July 2018, thereafter.
Lord, that's the application. 7-1C I am complying with.
From when?
Till date.
No, this suit was filed when?
2018.
2018. So this was prior to the filing of the suit.
Yes.
And
Lord, I have been, if your lordship comes to the order impugned, Lord, I have been held to be defaulter. Kindly takes up for we can order
from the months of July 2011.
11 to April 2026. Lord, nothing is being considered because why, Lord, I am asked. Lord, there is another revision pending. What happened? Lord, I filed an interlocutory application during pendency of the 7-2 when the witness action was continuing. I was about to,
in 7-2.
Yes, in connection with 7-2. I was about to lead my evidence. On that day, since the interlocutory application was filed, the judge got annoyed, said, no, you are
what
not.
What was the interlocutory application for?
That is for amendment.
Amendment of?
Order 14 Rule 2 application. Holding that, Lord, this particular instance suit, during subsistence of a suit wherein the receiver was also not being directed to take up all the legal proceeding since the receiver is appointed. Now, your lordship knows, without the leave of the receiver, whether the instance suit, filing of the instance suit is good or bad, that's the point, my lord. Nevertheless, an interlocutory application for amendment was filed in connection with Order 14 Rule 2.
What happened to that civil revision?
That civil revision is pending, my lord. I just want that this revision may be taken up along with that revision because it's interconnected.
There are two things. One is, as it also appears in this impugned order, that they have not laid evidence.
No,
that's
yes,
the recording in the
yes, my lord. And I have not also allowed to participate on.
So one thing, and he says the earlier order is not allowing him to lead evidence. That's under challenge. So if both the two civil revision applications are taken up, where is that application?
Before your lordship, it was admitted by your lordship's coordinate bench. CO number, 1026.
Appearing in the monthly list or the supplementary list?
Monthly list 2069.
CO 2069.
No, item number 206.
Monthly list item number 2069.
আচ্ছা এই মাসে আগের মাস this month July month list তো বেরিয়ে গেছে
হ্যাঁ মানে 8 জুনে যেটা
Since 2018, 7-1 not allowed.
Mr. Banerjee,
I do not
that's
know, my lord.
No, if another civil revision application is
Yes, that is all right, my lord.
If you are also appearing, let both these two civil revision applications
I
be
cannot
heard.
stand in the way.
That's one way. Second is now good, bad, indifferent might be for certain reasons. The fact remains he did not lead evidence.
But reasons are glaring. My lord, these are the reasons. I have all the orders.
Only one thing. If you want to proceed without the evidence, nobody knows what might happen at the subsequent stage. That's one way or the other. So let me see 2069 patent. Right?
Yes, both together.
Yes.
Yes,
both
yes.
these matters to rest.
That
That is what
application
I'm
has also
telling
been
you.
served.
So let both these matters.
Copy নিয়ে
You are appearing in the other matter.
But I
Copy
will
served.
No,
So that
I-
is also on the motion stage.
no. After admission, copy served. Affidavit of service is with me. If Mr. Banerjee do not have
But
the
I
document, I can-
undertake to appear. No problem, my client. is-
This entry order is till which date?
Tuesday.
Till Tuesday. Ashun.
all the same. The parties are different only. And the CO number, this is also closer, another CO is pending. The CO number will be 1028.
But two different tenants,
Different tenants, that's
same landlord.
Selling on the same boat.
Selling absolutely identical.
Selling on the same boat. ওইটা একই হবে the recording is also same.
all same, only the tag, the matter which will be tagged, the CO number will be 1028 instead of 1026.
ঠিক আছে?
I'm grateful.
Same order. Next.
The next matter, affidavit of service.
নাম্বারটা নিয়ে নেবেন, সিও নাম্বারটা নিয়ে নেবেন।
বলে দিচ্ছি। Great.
Mr. Mukherjee, please serve a copy upon him.
Yes, I will.
If not already served. Yes.
না থাকলে দিয়ে দিস।
My lord, the matter has been wrongly tagged, my lord. My matter, instead of Jalpaiguri Circuit Bench 2063 matter, Kolkata, this bench's appellate side 2063 matter has been assigned along with the matter earlier. Item number 1. But kindly peruse the last order, my lord. I have checked.
দেখি ফাইলটা দিন।
Five order, my lord.
The matters were listed on application.
That is Durga Das Adhikari versus State of West Bengal and others. 2063. জলপাইগুড়িটা এখানে হয়ে গেছে।
Jalpaiguri is 2063.
Yes, my matter is also was 2063 of Kolkata High Court, principal bench, my lord. Appellate side. The cost title is different, my lord. Kindly, if your lordships kindly.
Yes, cost title is Durga Adhikari versus
Yes,
and
my
others.
my matter is Arnab Dasgupta and another versus State of West Bengal and others. Maybe that has happened.
এলো বলুন তো শুভজ্যোতি বাসু
ওই ফাইলটা 2328 ওই বড় ফাইলটা দিন। ওটা 2328 জলপাইগুড়ি।
এখানকার ম্যাটার গুলো এসে গেছে
ওইগুলো দাও।
এটা অন্য ম্যাটার I think I am passing it over. Can you inform Mr. Shamim Ahmed?
I am informing, my lord. I am informing.
Please inform Mr.
I am
Shamim
informing.
Ahmed. I think he is for the petitioner 2328 and who is for the petitioner in 2063? The petitioner in 2063. 2328. Please ask Mr. Shamim Ahmed to come.
I am informing Mr. Ahmed.
এই ফাইল অন্য ফাইল এসে গেছে Yes, call the next matter. জলপাইগুড়ি ফাইলটা আছে কি বলছে None appears for the petitioner at the time of call. No accommodation has been. Next.
Might be appearing siege coming, my lord, make it short pass over.
Pass over. Next.
No, I'm for the petition. I'm praying for expeditious disposal.
Of what?
Title execution case is pending, and the opposite party have filed application under Order 9, Rule 30. Miss case is pending.
So you want the miscase to be disposed of?
Let be, I am innocuous in that effect. Opposite party is not here. Let both the matters, miss case as well as the execution case, be heard out within a specified time frame without granting any unnecessary adjournments.
This application under Article 227 of the Constitution of India
Item number 12, my lord, I beg to appear for the petitioners, my lord. My lord, I'll be very candid, my lord. I need to show the perversity. Apart from that, my lord, I have come to your lordship challenging an order which has refused stay to a section 14 order passed by the learned DN. The order has been passed by the DRT, learned DRT. My lord,
appeal is there.
yes, my lord, that's why I said, my lord, only the little scope of perversity. May I just indicate for my...
Please show that perversity before the appellate tribunal. In view of the The impugned order is at, my lord. It's of February, and we have filed in June.
I have lost that time.
Thank you, sir. Yes.
Lord, I'm for the petitioner, my lord. Lord, the petitioner are, my lord, defendants in a partition suit, my lord. Here the plaintiff, my lord, in the suit, my lord, claims.
My lord, I'm so sorry, my lord. My lord, the certified copy I filed it.
Then you have to withdraw.
Very well.
That prayer you have not made. Then you have to withdraw. If you want to withdraw, I can permit you to take back. Want to withdraw? তাহলে একটা লাইন লিখ।
Application for, my lord, rejection of plea.
Order 7 Rule 11 rejected.
Yes, my lord. Inter alia on the.
What is the ground under Order 7 Rule 11?
My lord, no cause of action, illusory, clever drafting, no cause of action. My lord, why so, my lord? The petitioner, my lord, claims to be a daughter of one.
Show
My lord.
me the plain.
Yes. My lord, may I just, my lord, two-line submission, my lord? The plaintiff, my lord, proceeded on the premise that she is the daughter of one Nimai Mohan Chatterjee and Meera Chatterjee. Now, my lord, the documents she relied upon the plain, my lord. That is one of the document is the PAN card of her PAN card, and the marriage certificate of Narendra Mohan Chatterjee and Meera Chatterjee.
So marriage certificate of the parents.
Parents. The
And
marriage
her PAN card.
Her PAN card. Marriage certificate apparently shows, my lord, that the marriage was held in 1989. Whereas from the PAN card, the date of birth disclosed, my lord, she is born. She was born in 1978.
PAN card date of birth is 78 and date of marriage is
1989.
89.
Yes.
Is the PAN card a document for date of birth?
My lord, she relied upon this document, my lord. And my lord,
that is the only ground. Yes.
No, my lord, there are one more ground, my lord. There is a probate. She also contended that we obtained a grant of probate was obtained, my lord, where, my lord, her father's share had gone to me. That
has gone to you.
Yes, had gone to me. That was the. She has pleaded it, but there is no challenge to that as of now today. The order of there is no application as of now for revocation of grant of probate. Though the suit was filing.
Please show me the plaint.
Yes, my lord. The plaint, my lord, is appearing, my lord, at page 24.
Page
24 of my petition. Start from page 20. At paragraph 6, she pleaded about the probate proceeding.
6.
Yes. Page 27.
Yes.
She
is claiming to be the daughter of Nirendra.
Nirendra.
Yes. So Nirendra also got that property by virtue of the will.
No, during the proceeding, my lord, he admittedly died in 2009. My lord, kindly see paragraph 8. He died in 2009, 31st March, and death certificate is also disclosed by the plaintiff. And her mother also died apparently on 16th October 2010. And the probate, though filed in 2006 during the lifetime of her father, but was granted in 2016.
So the property will devolve after the grant of probate.
But my lord,
Ashun, this application on
court, my lord, the last portion, observation parts, my lord, the second
page.
last page. Now from the plain reading of the plea.
Now from the plain, yes. Second place, yes.
It is found that the plaintiff has claimed herself as a daughter of the Nirendra Mohan Chatterjee, and the suit for declaration and partition has been instituted by her claiming her share in the suit property through her father Nirendra Mohan Chatterjee. It is appearing as pointed out by the learned advocate for the defendants that the date of birth as mentioned in the PAN card of plaintiff, wherein name of the so and so has also been noted, is much before the date of marriage in between.
So only ask the point of that PAN card.
No, what the trial court held, my lord, the trial court, my lord, said that if the date of birth mentioned in the PAN card is taken to be true, then the name appearing in the PAN card of her father is also taken to be true.
Ashun, this application under Article 2 Thank you.
And although I am not in caveat, Malad, a copy
Sam?
may be served, Malad, take up on Monday, Malad.
Lordship, only one thing, Your Lordship, as a hearing has been concluded. 7-3 notice, Your Lordship, given, I file a reply.
7-3.
7-3 of the PP Act.
Oh, PP Act. Oh, sorry.
PP Act. Your
Mr.
Lordship,
Nag,
7-3
Act.
of the PP Act, I filed a reply. 17 June, he fixed the matter on 1st of July at 3 p.m. Lordship, 11 o'clock, Lordship, he has concluded the hearing and posted the matter for 7.
Where have stated that?
Lordship.
I don't know, Malad, whether it is substantiated or not.
Mr. Nag, if it is on oath for the purpose of interim order, you are not on caveat, Mr. Nag.
Yes, that's true.
So I have to go by the affidavit. You
But
can
still,
come up.
Malad,
You can come up with anything for vacating if that
You
is
kindly take page
correct state
48.
of facts.
Page 48. Page 48.
But no, where have you stated in the civil division application that it was taken up at 11, though the time was fixed at
I'm
3?
showing the yes, Your Lordship. I'm showing the document first. I'm showing then
Page
page
48.
48. Your Lordship, kindly take first.
3 p.m.
Page 48, 3 p.m.
Yes.
Now, Your Lordship, kindly take page 51.
Yes.
Kindly sees the proceedings held on. First, Your Lordship, kindly sees that. Third line from top.
11 a.m.
11 a.m. Now, Your Lordship, kindly see the date. Hearing concluded. OP liberty to file written pleadings within 7th.
So you are present?
No.
Yes, yes.
I was present, Your Lordship, before the Honorable High Court. When Your Lordship, we were doing that particular matter under the PP Act where Your Lordship granted the stay. 11 a.m. Hearing concluded.
Live streaming is to be open now.
But there is one opposite party, somebody.
Yes, Bidan, he has gone to collect Your Lordship a certified copy. His name has been recorded and concluded the hearing.
So Nag, what is being done?
No, I don't think so. Malad. I have to take instruction, of course.
Para 13. In the civil division application.
Civil division application, where have you stated?
Page 6, para 13.
Page 6.
Para 13. 13, 17, Your Lordship, kindly says.
The order dated 1st of July 2026.
Though I'm not in caveat, I have instructions to appear.
for opposite party number 1. No one is there to propose. Whom he will oppose? None appears for the petition at the time of call. No accommodation has.
That I appear for the petition. This is also, my lord, that proceedings under the Public Premises Eviction of Unauthorized Occupants Act.
Mr. Nag has made this monopoly.
He is an expert on this subject. Lord, I take help from him also when I am in difficulty. Lord, this is, Lord, a slightly different case. Lord, a notice is served upon me. Your lordships may kindly
Notice
come under the section 4. Now, Lord, the notice says, if your lordships, Lord, kindly come to, I'm Lord BPCL. I run a petrol pump. There was a lease from 1968. This is an established petrol pump. I run it through an agent. I appoint an agent. There is a national policy of central government, Lord, Petroleum Ministry, that, Lord, I can run a petrol pump through an agency. He is my agent. Now, Lord, what happens is that
Who is your agent?
the opposite party number 2. Pro forma, 3. Now, my lord, what happened is, I receive a notice under section 4, which is at page 80. Kindly come to the page after it.
Clarification, Mr. Court. Is the estate officer a necessary party in a proceeding?
It should not be. After all, my lord, the judgments to say that tribunal need not be made a party. Your lordship will permit me to, my lord, delete the estate officer, but sometimes, my lord, because they are departmental nominees, they are, my lord, impleaded.
Unless you have some acquisition of bias.
Here we have. I just want to tell your lordship what has happened.
Yes.
Just, my lord, give me 2 minutes. Now, my lord, once the section 4 notice is served, the section 4 says that, my lord, the application filed by the port trust is a part of the section 4 notice. The grounds that are computed, if your lordships kindly, my lord, take the section 4 notice, that's come to after page 85. Just after page 85. The certified copies are not paginated.
After page
85. This.
So after page 85 is something on a stamp paper.
Stamp paper? Oh, that must be, Lord, the application for certified copy was there.
This is the power of attorney.
Oh, kindly, my lord, see the estate officer's, my lord, notice form A.
Yes.
Has your lordship found that?
Yes.
Now, my lord, this is issued on 16th of June 2026.
Yes.
My lord has seen this. Now, my lord, kindly turn the page, come to the next page, page 2. At the top, your lordships will find an application from SMPK dated 15 June 2026 is attached here to, which also forms part of the ground. Now, my lord, this application was, this notice was served with a direction that 24 June 2026 at 3 p.m. I should appear. Your lordship has seen that?
Again 11 a.m.
No, Lord, here luckily not 11, but Lord, something more than that has happened. Lord, I have in my career I have never seen the summary proceedings to be such a summary proceedings. Your lordships may kindly come to the next page.
It has become pressy.
Not even pressy. Lord, he thinks that whoever it is thinks that I am estate officer, I can do anything. Lord, CPC does not apply. Evidence Act does not apply. Even the principles of natural justice also does not apply. Lord, kindly have a look at, Lord, the order of 16 June. Has your lordship?
Yes.
Now, Lord, 16 June is the order by which the notice is issued. Lord, your lordships will kindly see the second page of the notice order. It says, after careful consideration of submission made by second page, second paragraph.
Yes.
After careful consideration, submissions made by SMPK, material produced before me, I find that SMPK has made out a strong case to proceed against OP, etc. And then, Lord, the notice is issued. The fourth paragraph, your lordships will find notice issue.
Yes.
So, Lord, the strong prima facie case he finds on the application of SMPK. Now, Lord, kindly see when the matter appears I am asked to appear on 24th June. I go and say that you have served me a notice. The notice does not contain an enclosure, the application. Please ensure that that notice is served. Your Lordship will kindly come back to the notice and see the second page. Your Lordship will find it does not contain any enclosure. Kindly see the notice at the second page. Lordship will find no enclosure.
But according to you, this notice refers to an application of SNPK.
SNPK, because blood notice, it's not a suo motu notice. Under section 4, blood, there are two options given to the estate officer. One, blood, on the basis of the application. Otherwise, blood, he can also issue a suo motu. Here, blood, section 4 says that there is an application based on which this notice is issued, and that application is formed as a ground of the notice. Your Lordship has seen that. Now, Lord, I go and I appear and I say that give me time and give me a copy of the application. On 24th June 2026, Lord, the matter is I am allowed time only one day. 25th June, I am asked to file the application, my pleadings. Your Lordship kindly sees that order, 24th June 2026. Yes. It says, concerned OP number 1 appeared the matter, verbally placed their submissions relying certain documents support of the OPs, sought for time to file their respective replies in writing. Prayer as sought for above replies is hereby allowed. The opposite parties are directed to file the same by 25th June 2026, along with necessary documents credential in support of their individual case, failing which the matter shall be decided on the basis of documents already on record. Now, Lord, the documents already on record is not, Lord, supplied to me. Now, Lord, on the next day, I file a formal application. Lordships may kindly, Lord, come back to page 65. Kindly see, Lord, I file a formal application. Kindly see my Lord, second paragraph, where I say that 16th of notice dated 16th was received by me on 19th. Your Lordships will find that. Then, Lord, kindly see on paragraph 3, it says that I appeared on 24th June 2026.
What did you pay for this in this application?
I prayed for, Lord, paragraph 5. Lord, I pray for service of that application and granting me 4 weeks time to from the date of service of the application to file my rejoinder.
What happened? That has been rejected.
That not only rejected, final order of eviction.
Mr. Nag.
Kindly see page
Yes, Mr.
25th
Yes,
June.
Here, if Lordship takes,
please give me a minute.
Kindly have a look at section 4. To the show cause notice, 16 June file an application petition praying for 4 weeks time to file reply to show cause notice. This is sudden. And OP number 2 filed an initial reply to show cause notice with an application for extension of time to file effective reply. Consider both such applications of the OP it is pertinent to mention, proceeding is strictly confined under PP Act and summary in the nature and in nowhere compels OP's personal appearance, attendance before the court. All that is need is reply to show cause filed by the OP within statutory period of 7 days. That's the mandate of Section 4. Within supporting documents in support of the case, it's needless to mention taking up adjournment, no one pretext or further basic spirit of the Act. Hence, without considering OP's prayer, on the basis of available documents, I am disposing the proceeding here. Now, I'm pausing here for a moment. Now, Section 4 demands that the show cause has to be given. Show cause has to be given to the notice. Show cause notice is. Well, there is no provision that you have to give the show cause notice to any application attached to. Application is just to draw attention of the estate officer. Then what is the fact? Now, my lord, one thing has to be clear, my lord. OP number 1 is not running the petrol pump. OP number 2 who has filed the show cause notice is right, and today the due is 5.64 crore.
Mr. Nag, evict an unauthorized occupant. I'm not against evicting an unauthorized occupant, but do it in a proper manner.
But the notice is incomplete. The notice that he has served
on one day it appears, on the very next day reply is to be, I think we have also to follow that procedure.
I'm going to kindly have a look at the.
I think High Court also have to adopt that procedure. Correct. On the next day, you file your affidavit. Thereafter, it will be hard.
And especially in matters where, Lord, my learned friend clients are there.
I think that should be done.
Page 65, my lord, once.
And
it's not about one day. That's the
yes, Mr. Nag. When the notice was issued, where is your document when it was served?
No, it was section for notice was issued on 16 June.
Yes, when it was served.
Right, it was served. They received on the next date, very next date.
19.
Application. Kindly have a look at the application that is by Mr. Kaur, page 65.
Is it Mr. Nag? Natural justice means an effective opportunity, not merely an opportunity. Not merely an opportunity.
Section 4 notice. Two things. I bow down to what has fallen from your lordship.
Mr. Nag, two things. I'm giving you two options. One is I'm setting aside this, given them an opportunity, proceed in accordance with law.
I'm not let them serve the application which is forming ground of the notice. The notice is incomplete.
Some document, not giving copies to the other side, because this notice says this is attached here with and forms part of the record.
And I want my learned friend to read 4 subsection 2, which clearly says that after the notice is served, if the notice is incomplete, 7 days doesn't run. My learned friend's client is under a wrong impression.
Mr. Nag, you can take instructions. I can give you.
The decree.
Section 4 notice says,
Mr. Nag, choices will then have to stay this. I will hear you.
Next.
I will hear you.
Next witness. Well, I'll come back with instructions.
With instructions.
I am the lessee.
Steps on this. Don't take any further steps on the basis of this. It has to be done.
Pass a judicial order? No.
No. I will pass a judicial order. Yes. I'm not asking you to give consent. I'm not asking you to give consent.
I cannot.
Yes. Do you have a copy of the public premises at eviction of unauthorized? Representing an authority. Please give some advice to your client. What advice? That's up to you. This should not be the manner in which this proceeding should be proceeded with.
And Lord, there is a practice direction.
Because in two matters on a particular day, I have come across this.
Lord, there is a practice direction issued by the central government. I think it's part of this book. If your lordships kindly sees, the guidelines, Lord, that has been issued by the central government. This is, Lord, I don't know whether it contains in your Lordship's book. Kindly come to the last page. As to how these proceedings are to be conducted, there is a guideline
Yes,
issue.
guidelines.
Yes.
Guidelines.
Kindly, my Lord, come to Roman 2, Roman 3. A person in occupation of any premises should not be treated or declared to be an unauthorized occupant merely on service of a notice of termination of tenancy.
One thing I need to point out, the OP number 2, গ্রেভাল কি এটাই?
না না এটা ভারত পেট্রোলিয়াম গ্রেভল
Actually, OP
Right.
number?
Who is the running the
Where they have obtained an order of stay.
I have received? I'm sharing with my learned friend.
They have obtained the order of stay.
By filing a miss appeal. Miss appeal, they have filed and obtained an injunction.
Who?
That is Grewal Auto. OP number 2. OP number
Sir, I have no instructions. Otherwise,
here is already.
I have no
posted
instructions.
Services.
Kindly, my Lord, that does not absolve, Lord, my client from challenging the order in
The order is state, but what is the necessity of
No,
passing an order?
I don't know whether it is state. I want to stay so far as I am concerned. Kindly, my Lord, see the guidelines, my Lord, 2, Roman 3. A person in occupation of premises should not be treated or declared to be an unauthorized occupant merely on the service of notice of termination of tenancy. But the fact of unauthorized occupation shall be decided by following the due procedure of law. This is a due procedure of law.
7 days notice was given.
Further, the contractual agreement shall not be wound up by taking advantage of the provisions of PP Act. At the same time, it will be open to the public authority to secure periodic revision of rent. But there are two central government entities. I am a central government entity. Right. This has become a farcical, Lord, situation. The instruction clearly says, in other words, the public authorities would have rights similar to private landlords under the Rent Control Act in dealing with genuine legal tenants. I'm running a petrol pump central government entity, my Lord. I really don't understand.
Not paying 6 crore rupees.
6 crores, we will see.
You see, what is see?
I am not running away.
Central government not paying.
There'll be no-
I don't know.
The orders.
No adjudication, no notice on dues as yet.
take instructions.
Yes, and I will convey.
Because yes, Mr. Ahmed.
Sorry, but I couldn't.
Is that this matter has been assigned. Now, your learned friend submitted that this matter has been disposed of. So, but I found that it has been assigned to me. Then I asked him to go through the papers.
No, so far my matter is concerned, it is not disposed of.
The problem remains the number which has been mentioned. This is the same number in Jalpaiguri and this court. So, this number in the principal bench that has been disposed of, but this number of the Jalpaiguri is pending. So that created the confusion. The cost title is of the
Principal bench.
Principal bench. Now, I'm making it only not today. Please appear on Monday because this has to be clarified first. Because this is an order of assignment. This has to be clarified first. It is not today করে দিন আমার কাছে।
In this matter, Mr. Lokhi Gupta was appointed as amicus. There was another writ petition which was dismissed for default. Both the writ petition was assigned before this bench, possibly.
Yes, 2 writ petitions have been assigned. Then one dismissed for default.
One dismissed for default.
Then
I'll ask them to restore it.
What can be done, Mr. Ahmed, if it has been, it's a big matter. All right, please take steps. I'm keeping it. কবে রাখবেন? মঙ্গলবার, Tuesday I'm keeping it. Tuesday কিছু এমনি করার দরকার নেই, এমনি normal order. I'm keeping
some sort of mechanism needs to be done. Otherwise,
because after it comes here, some different numbers needs to be assigned. I'm coming after 5 minutes. So this Tuesday.
My lord, I am appearing in this matter. My lord, in this application, I am praying for expeditious hearing of a suit.
Suit. What is the suit for?
The suit is for revocation of succession certificate granted by the learned district delegate Alipur.
So revocation proceedings you want expeditious.
Yes, my lord, I am the defendant in the suit, my lord.
This application.
That I beg to appear on behalf of the petitioner, my lord.
Yes.
Being led by Mr. Sujanil Das. My lord, in this case, my lord, one title suit was filed before the additional civil judge senior division in the Hooghly. My lord, the plaint would appear in page number 28. Now, my lord, what happened? The plaintiffs in the suit, in that particular suit, against them, regarding the same premises property, a suit has already been pending before the Rajarhat Commercial Court, and we being the plaintiff, in the commercial court, we have obtained an interim injunction order. My lord, the interim injunction order they appear in page 88.
Yes.
Yes, my lord. Page 88.
Yes.
Starting, my lord, and the actual details of the property would appear in the page 91.
Did you produce the plaint before the learned trial court? Plaint of this suit.
My lord, I'm placing that. My lord, during the course of the proceedings, my lord, we have filed a section 10 application for the stay of the suit on this regard. My lord would find page 93. My lord, page 93.
Yes.
The plaintiff in the Hooghly suit, they admit they took an action.
I'm asking you, did you produce the plaint of the commercial suit before the learned trial judge?
My lord, we are now during the hearing, my lord, sufficient documents could not be produced.
Then
my lord,
there is no information.
My lord, kindly hear me. My lord, kindly allow me to go back and kindly give an hearing. My lord,
Take this before the learned trial judge.
Page 93, my lord, they have admitted the fact.
Maybe the learned trial judge, you have not produced those documents. How could there's no infirmity in this order?
They have admitted the fact that regarding the same
But
property,
unless you produce the documents, how can the court go through that? Whether it's same or different.
My lord, there is an admitted fact, my lord, admitted fact.
If you want, then you have to withdraw this, you take steps there. There's no infirmity in the order. That's up to you.
My lord,
you want to go back?
I'm kindly prefer an adjournment for today, my lord.
Pass over. Next.
Thank you, my lord. I am.
Yes.
The defendant is the petitioner, my lord, before my lord.
मतलब due to मतलब the acute मतलब gastric and pancreatitis problem, मतलब the learned advocate could not attend this court and मतलब file adjournment petition. Now kindly comes to मतलब page
Rejected.
Rejected with cost. मतलब what happened?
Rejected with cost.
मतलब kindly see.
Adjournment rejected with cost.
मतलब 12th May was the date fixed for मतलब the taking.
Please show me. Please show me. Adjournment rejected with cost.
मतलब kindly first come to page 49. The first adjournment petition.
49.
ना दुटो order ना देखो.
40.
49 में 12 May 2016. 2026.
Yes.
मतलब the grounds मतलब the stated along with the medical documents.
No, 12th May was the date fixed.
Was the date fixed.
Yes.
Now मतलब that day मतलब the 12th May order is page 51. The learned court मतलब granted adjournment by fixing a date on next date 13. मतलब kindly consider मतलब the for engaging मतलब the petitioner is the company for engaging मतलब the learned advocate to proceed with this case. मतलब some formalities is there. Very next date मतलब this is very on next date also another adjournment petition मतलब the file on the same ground. मतलब since the learned advocate was in the hospital by the order.
No, your prayer was allowed.
No, that is the first day.
No, 13th of May.
13th allowed.
13th of May, it has been allowed. What are you saying? Certified copy.
No, 13 allowed.
So that is the subsequent.
Sorry. 13 allowed with cost.
Yes, that is what I was. You said rejected with cost. I was surprised with that. Now it's allowed with cost, Mr. Bose.
Kindly consider 2 days. Kindly consider 2 days.
You cannot challenge it in part.
Kindly consider this.
Either you accept the entirety or you challenge the entirety. You cannot accept the what is beneficial to you and challenge the other portion. It's a condition.
But I am
it's a conditional order, Mr. Ghosh. You cannot accept one part which is beneficial and challenge the other part.
I am ready and willing to I have in the meantime I had engaged another lawyer. Kindly consider this aspect.
What is the next date fixed?
On Monday. Monday I shall participate. Kindly waive the cost part.
Who are you?
I am the defendant. The state
no, that I understand. You are the defendant.
Now, kindly consider this aspect.
If you want, I can increase the cost.
Kindly
I can increase one or two zeros on the right hand side. That's the lowest integer on the right hand side.
Consider this aspect 12. The adjournment paid for on the ground of the learned advocate. If the matter is fixed on the 2-3 days after, that is possible for the company to engage another lawyer. Some formalities.
Mr. Adjournment prayer was allowed.
Regarding the cost part, this cost part, kindly see on that the previous cost was.
Company is a monopoly.
But
it's a monopoly.
But by the way that the date has been fixed, without giving.
You are also a consumer of company. You are also a consumer of that company.
But kindly consider this aspect. 12, if the learned court fixed any date, I got the 2-3 days time. Very next day that.
Only difficulty, Mr. Ghosh, is that other side is not here. That's the difficulty. Amount is not much.
Highly, otherwise,
other side is not here. But unless you deposit on the next date, it will also. Why have we challenged it now? 13th of May 2026, and we are challenging in July.
No, July is the date fixed.
Maybe.
No, I have.
Maybe.
Now, some formalities, that the engagement.
What formality?
Engagement, preparation of draft, then vetting, all these things, the time consumed. This is not the
Mr. Ghosh, only one thing.
Only that ground, kindly consider.
Then the ground is that you have to pay the entire fare charges and stay charges. So if another day, because that witness will come, then again it will enhance.
The learned court, the considered the condition of the learned advocate. That is also the due to acute the pancreatic and gastric problem. He was in the hospital. So for engaging another lawyer, that
Do one thing, deposit this amount. I'm directing them to, then subject to the result. If you succeed, you will get back that amount. Otherwise, that goes. And I will appoint a special officer. In his custody, this amount will remain. The difficulty, Mr. Ghosh, Monday is the date. Unless you deposit, you will not allowed to examine or cross-examine whatever it is. That's the difficulty. And I cannot set it aside without hearing the other side.
So in that even here this I say subject to the result of this.
Subject to the result, please deposit that amount. That will be also subject to the result. You win, you get, you lose, that goes to the other side. And I will appoint a special officer who will keep this amount.
But I am not avoiding. Our difficulty is that we cannot engage in the
Only difficulty, Mr. Ghosh, if time was there, I could have directed you to serve and come back. Where is the which court?
The commercial court. Rajarat.
Who is appearing there? Commercial court? Who is the advocate who is appearing?
That's
Who is the advocate?
that I have to know.
You can take instructions, bring him. You're Rajarat. So must be someone from here who is going there. You can catch hold of him, bring him, something can be done. 2 p.m. 2 p.m. Things will go on or yes, Mr. Basu.
Yes, yes.
What is your instructions from 2 p.m.? 2 p.m. come back. Otherwise, 2 p.m. Rakuntat. Please see who is the other side. If he is available, please bring him. Yes. কিছু নেই মামলায়।
প্রচুর কিছু আছে, দুটো brief।
Looking at the council's there's no impugned order.
Because their adjournment refused.
Adjournment refused. Rightly.
It's a case, madam. This is a decree passed under the West Bengal Non-Agricultural Agency Act.
Yes.
The
Then
decree was passed on the day. This is not for your office. This matter is not before one. This matter is pending. Just and give the hint. What is the point we involve? Decree was passed on 12th May 1981. This act repealed on 9th September 1980, giving effect to 7th August 1969.
retrospective effect.
Repealed. No second saving clause. What is the effect of that? Your Lordship's Court, at least in two judgments, my lord, one author of Justice Somir Kumar Mukherjee said that there is no effect of it. If it is executed, executed. If it is not executed, you cannot execute that after the declaration of the act. In spite of that, my lord, the decree has been passed and police self application has been filed against that matter we are before the Lordship's Court in the civil division. In the civil division jurisdiction, when the was extensively heard by Justice Raja Basu Chaudhary, and there is a consensus between the parties that at page 240.
Yes.
Yes, madam. Can you see that order? Since it is submitted on behalf of the opposite parties that no steps would be taken to proceed with the execution for the time being, let these matters stand adjourned and appears in the combined monthly list of December 2020.
under the heading hearing. Thereafter, we tried our level best. What appears for the Honorable Single Judge. The Honorable Single Judge, in his lordship's practice, is asked us to file within the lordship's within the submission. We make it ready. Thereafter, we file an application before the court.
So extensively hard before another bench. So I'm directing this matter to this.
But protect me if in the meantime execution police help is granted, my lord, what I will stand. I am ready to argue that matter. This is the point I want.
What is the impugned order?
Impugned order is, my lord, when we come to, we have filed an application saying that this is the situation. The opposite party said that they will not proceed with the matter. Kindly rest in your hand. The court, my lord, without recording my contention in the application, is proceeding on this matter. This is my grievance. This one is 17 January 2026. It is not properly arranged. All has been annexed. 17th August, January 2026 and 23rd. Yes, 13 February 20th March 2026. I got it. If not, kindly pay.
So 17th of January I have got.
Difficult, kindly pay.
Then what is the other?
20th March. So, whisper of our application, we have made a substantive application giving details that this is the proceedings pending here. Kindly stay here. This is a decree which is null.
What happened on 11th of May?
That
11th of May was the next date.
That execution had not been effected till date. And there is a case where decree, according to me, is a nullity. Inexecutable.
Where is the application which you have filed for saying that it's not executable?
That is civil revision.
47.
That stage we take this point. Yes, in 47 we take this point.
Where is the order passed in 47?
That is in the other revision.
You have not annexed here. So why have you made it? Then I have to dismiss this. So many papers. That's the only thing which is relevant. Has not been.
No, application has been annexed.
Where is that application?
Application has been annexed.
Not the civil division application. The order passed on 47.
Come to page 36 of the lordship.
Only 36. Or there is something before or after that 36.
Yes, hello. 30th July 2024 is the order.
So this is a civil division application.
This is the date of the order, 30th July 2024, by which the execution was sought for, execution was going to be affected. We have challenged that. Badly arranged.
Non-agricultural tenancy is not in the specified act.
It is repealed now.
Prior to no, act is subsequent.
At that time, point of time, there is
LRTT Act is subsequent. LRTT Act is subsequent.
Yes, but 231 is the order, which was challenged in the previous civil.
231. 47 rejection.
Yes, this is an application, my lord.
May not be, yes, 47.
Lordship judgment is that division bench said this decree is non-executable.
No, this is not rejection of 47, Mr.
No, this is my lord. Then application is going to be kindly come to the concluding portion of
208.
This is yes,
208. Yes, section 47 order is has not been challenged. If the section 47 order has not been challenged,
that has been challenged. That is not before my lord. That is not before my lord. This order was subject matter of challenge. Where we have prayed that
this is the subject matter of challenge before the other civil division application, where you said that the coordinate bench recorded the submissions that it will not be further. Yes. So, but what is the fate of the section 47 has been dismissed?
In spite of that, the party agreed that the execution would not be effective. That is now my lord consideration is this.
That is neither here nor there, Mr.
My lord's
Basu. If
consideration
the
is
47 has been dismissed unchallenged, how can you now say that the decree cannot be executed?
I cannot now recall, my lord, whether it is dismissed unchallenged.
Mr. Basu, that's important.
I cannot
Because
recall.
Mr. Basu, if 47 you have filed, because here the IO filed such and such
This is
made mistake.
I am praying for a breathing time till this divisional application is decided.
Non-agricultural tenancy at its preemption.
Yes. And there are other points also, my lord, where it requires a kind of execution requires an application to be filed. That has not been filed. But that I can say, otherwise I can say that this statute is not applicable because of repeal.
Where is that order? That coordinate bench recording page.
231. 240. 240.
Mr. Basu, senior advocate, appealing for the petitioner submits
Get it from Justice Hiranmoy Bhatt, because before getting this, he is elevated. So still it is clear.
Number 21.
Yes.
Appearing on behalf of the petitioner, my lord.
Who is appearing?
Anyone Mitra is appearing on behalf of the petitioner, my lord. Kindly take it at 2 p.m. my lord. He is on legs with the Honorable Justice holding up.
The honored advocate appearing for the petitioner may be just.
Number 23.
23, my lord, I have the PMT.
PMT, lost in both courts. What remains? Please vacate.
What
Yes, what is your point here now?
My point is that, well, I thought the government benefited scheme I was enrolled. I thought subsidy as per the government scheme.
So that order in miscellaneous appeal is under challenge.
No, both the orders have been challenged. In the mis appeal, I have stated.
Yes, yes. What is the ground in the PM, this matter?
Ground preemption is on the ground of incidents. Well, in that case, my lord, I find the difference that during the pendency of the case, my lord, I was benefited by the government scheme of Pradhan Mantri Awas Yojana.
That's neither here nor there, Mr. Das.
My lord?
That's neither here nor there.
No. That is my argument.
Yes. So that right goes.
That right goes now. Whether the government scheme.
How the preemption, right of preemption gets defeated
by the government scheme.
Government scheme, it gets defeated.
Yes.
Please show me an authority on that.
Kindly see concurrent list of the Constitution. Concurrent list.
Yes. So what?
Kindly see 12. Right hand side, 12.
Yes. Evidence and oaths recognition.
This person. After when I inquiry from the Panchayat, I got this was benefited from that scheme. This is my ground. But I will be.
Please show me that you have taken that ground.
Yes, in the memo.
Yes. Not in the memo of appeal. Please show me in the judgment you have raised that point.
Yes.
In the miscellaneous appeal.
Yes. But kindly see para 4. Argument number starting from where the grounds of appeal ended in memo of appeal.
Page 4.
Not page 1, it's not that. Page 15, page 6. Sorry, but page 6 of the appeal court type.
Yes.
Starting from the grounds where the appeal ended in memo of appeal. Learned advocate for the appellant argued that this is a unique case where there is no specific law setting out a line of defense that can be taken in the matter of exerting a right of preemption. Where the partisan has obtained the benefits of government-sponsored scheme for constructing a dwelling house on the land, which is the subject matter of preemption. We argued that the opposite party number 1 is that's my time, is a poor fellow who has no other land or property elsewhere, save and except the land in question, which is purchased by selling all his properties, and that he already having obtained the benefit of government-sponsored housing scheme, invested money on the disputed land in constructing a dwelling house, and as such, he cannot be deprived of his benefits in the guise of exercising a right of preemption by the petitioner. Under the provision of the West Bengal Land Reforms Act, he further submitted that bringing the opposite party number one, bringing the beneficial parameter of a government housing scheme, otherwise describes its poor financial status, which the learned transport ought to have been borne in mind while passing the interim judgment. As such, instead of including the transfer in question, learned court below ought to have given a preference to the rule of equity. He argued that the interim order has only done injustice to the applicant, but has also deprived him of enjoying the benefits of a government scheme, which the government already considered him deserves to enjoy. He submitted that in a situation like this, the rule of equity ought to have been given the topmost priority by doing injustice to justice, and the learned transport failed to appreciate the case of the appellant opposite party. He submitted that if the impute judgment is allowed to stand as it is, there will be a sheer miscarriage of justice, and the appellant in such a case is likely to face irreparable loss and injury which cannot be compensated by adequate damages. He argued that for preservation of the rule of equity and justice, the impute order needs to be set aside, which, if done, shall not cause hardship to the petitioner, in as much as they have more land and.
Which page you are placing, Mr. Das?
Page 6 of the appellate judgment.
Page 6. Please
Yes.
kindly come to page 10, last paragraph. You need not take the trouble of placing the entirety. Please kindly come to page 10, last paragraph.
In addition to this is. In addition to what this paragraph.
Yes, yes.
Described in the above paragraph, it is.
Yes, what is the infirmity in that finding? From page 10 to page 11.
Infirmity in the finding that I have a beneficiary under that scheme. But kindly see what was the preamble, why this scheme has been launched. Kindly see the preamble of this. Kindly see. First 4 lines. Pradhan Mantri Awas Yojana is a credit-linked subsidy scheme by the government of India to facilitate access to affordable housing for the low and moderate income residents of the country. It envisions a target of such and such under Pradhan Mantri Awas Yojana, urban and Gramin. But this was the preamble, and kindly see the scheme. Government, it is the intention of the government by not to that low income people should get a shelter. For that, my client was benefited by the scheme. Not benefited, but he was one of the beneficiaries. He raised the construction. But therefore, rule of equity should prevail, madam.
Anything more, Mr. Das?
Then I will be homeless, madam. But kindly consider these, and kindly see this one territorial Article 3, 7th of the Constitution, Schedule 7. Kindly see whether which one will prevail. The policy should prevail. That is the.
When the amount was sanctioned in your favor, when the transfer was made, when the
transfer
amount was...
I purchased in the year 2008. My last transfer I was benefited after some period.
After some time.
Yes, and I already started construction.
9(2) comes into play.
My last.
9(2) comes into play.
But the government scheme, my lord, it is a but kindly.
Everything within the expression or otherwise. These two persons on your extreme left, they are the architect. Two extreme left.
I will argue on the kindly.
Now urgency vanished.
Not urgency, not urgency. That is but can you admit this give stay? I will argue.
Admit stay. Please cross the first hurdle, Mr. Das.
But kindly, if you lordship take the constitution, my lord, and the government scheme, but this is the intention of the central government to provide housing for all the.
Please apply for settlement from the central government or the state government.
No,
From
they
their
have
property.
filed the execution, my lord. I will be evicted on Monday. Kindly.
That is why I have upgraded it. I've taken up today.
Yes, I mentioned.
Now I'm considering Mr. Das. Stay is not a matter of course.
I will be evicted. A homeless person is 70 years old.
You have taken the risk. You have converted it during the pendency of a proceeding. Without converting that, you have constructed on a Shali property. Those are the findings, Mr. Das.
The findings
so you have
are there.
taken that risk.
The findings are there.
You have taken that risk. Have you converted that property from Shali to Bastu?
Yes. Yes.
When?
During the pendency of this preemption.
Asun.
Item
Please.
24, very next matter, they are
Please wait,
asking,
please wait,
they are asking for particulars, other side. I am for the opposite party number.
please wait. After this judgment is
Ashok Krishnan sir is appearing for the matter, but right now it's court number 29.
can you come at 2 p.m.?
Sorry, no, sir. Lordship.
Yes.
Well, for the petitioner, marriage took place by 2008. Thereafter, present petitioner married with another lady, and thereafter the present complainant filed a petition 498A, and she filed one police in action case against the present petitioner and others.
Yes. Yes.
Kindly see the allegation. Main allegation against father-in-law 376. They have been granted bail by the court below.
Who are you?
The petitioner's husband.
You are the husband.
The husband.
Father-in-law has.
Father-in-law and the second wife has been granted bail by the court below. I've already annexed, my lord.
Yes.
Annexure P1, my lord.
P1.
P1.
Page.
Matter certificate. Dual man, page not 12.
Yes. What is the yes, madam? What is
Lordship, kindly look into page number 23. This is the 164 of the victim lady, Lordship.
yes, allegation is against the father-in-law.
Lordship. 9/10/2025, the allegation is against the father-in-law, but as per the husband is concerned, she was married around 15 years back. She was subjected to cruelty, both physical and mental. And then she discovered that she was married again, has a daughter. So this is all that she has against the husband, but the main
My lord, my lord, in the petition they filed, they disclose the name of the victim, my lord. Kindly peruse, my lord. I have the Sartak copy. I have downloaded from the Sartak. They do not say
Where is the writ petition?
I have my lord, this is a download copy from Sartak, my lord. And the petition itself is, my lord, infructuous, my lord. Because there's a
When this
judgment
writ
of
petition has been filed.
Nipun section as judgment, my lord. Kindly peruse. And the one Professor Mulla's judgment, my lord, or High Court judgment, my lord. They disclose the name of the victim, my lord. My lord, kindly see my petition. I've already stated, but not disclose any name of the victim or any related.
Now that's the different proceedings. Writ petition, you take steps there.
Disclose my.
Call the next matter.
Number 25.
Yes.
Right, in the year 2022, my lord, I filed a suit for declaration that I'm entitled.
What is the impugned order?
An impugned order, my lord. What in 151 application filed by the defendant, they allowed to construct the roof. Your lordship, kindly see the impugned order.
Allowed to
complete the roof. Subsequently, my lord, they filed a put-up petition on 8th, my lord, day before yesterday. That was also allowed to keep the police. But I got the said order, my lord, from the internet. My lord, kindly produce this one.
Who are you in the suit?
Yes, I am the plaintiff of this suit.
What is the suit for?
Suit for declaration.
Only declaration or partition also?
No, no partition. Only declaration that I am entitled to get the 10/9 of the share in the scheduled property. All on a sudden in the month.
Who is the defendant? He is your co-sharer.
Co-share.
How the suit is maintainable?
Because, my lord, there is no
Without any
demarcation.
partition?
There is no demarcation, no partition as yet.
How the suit is maintainable?
Well, that I will satisfy your lordship in
Yes. So he is in possession. Defendant is also in possession.
Defendant is also in the possession.
So what was the stage of construction at that point of time?
Pillar was made. Pillar was made. Kindly see the commissioner's report. There was a commission appointed. Commissioner's report will not kindly see.
Already constructed house, only the roof has been constructed. Mr. Chatterjee, without claiming any equity.
Kindly see the commissioner report. Kindly see. The page 58, last part. Page 58, last
Now the
part.
construction has been made.
Pillar has been made. Only
What is the stage now?
Stage is below. The pillar has been made.
Roof has not been constructed.
Wall has been made. No partition wall.
Roof has not been.
Roof has not been.
Where is the?
Kindly see the commissioner report.
Yes, page.
Page 58, last part.
Yes.
Last paragraph. At the 11th hour, when I am reading, at the 11th hour of my local inspection, the plaintiff said to me that except aforesaid Pakka residential house, the defendant encroached about 6 to 7 feet on the southern side of the aforesaid residential house by constructing concrete pillar into which the passage of the plaintiff totally obstructed. This was the findings of the London Advocate Commission. And my lord, 8th, my lord, they filed a put-up petition. On the basis of that, police help was allowed.
So by this, they were only allowed to construct the roof.
Yes.
That is what you are challenging.
In injunction application, status quo was passed. Well, kindly register. Otherwise, my entire suit will
This
be.
commissioner's report supports their case.
But last part commission report support my case, my lord, also.
It has to be read as.
They have encroached 6 to 7 feet.
It has to be read as a whole.
Even
when the encroachment will be removed, everything will be removed.
Well,
including the roof, everything will be removed.
Totally by obstruction has been made, my lord. That is the commission report.
Chatterjee, when even if the roof is not constructed, the pillars cannot be removed now. So let it remain encroachment. If it is removed with the roof, it will be removed. This application under Article 220. It has been made subject to the ultimate outcome. Learned trial judge has made it. That is why I have recorded that. Yes, call the next matter. Yes.
This is an application. Expediency is suit filed in the year 2018. As on date, cross examination of PW1, matrimonial suit, desertion and cruelty.
Who are you?
And the husband. What strategy the wife has adopted? She is appearing, then disappeared, then show cause, then leave the show cause.
Appeared, then disappeared.
Yes. That is the strategy twice.
This application under Article 27 of the Constitution. What is the impugned order?
Right on, my lord. 17th February 2024. Your lordship, this is first I shall place before your lordship. Now your lordship kindly have a look to the application filed for
Injunction, prayer for injunction rejected by both courts.
I am not before that below. I shall have to place below whether that will sustain or not. The order passed by the Nalaran appeal court below, whether it could be sustained or no. This is my only submission.
What is the stage of the suit?
Lord, here your lordship passed the order. I am placing this order first on your lordship. Kindly take.
I'm asking you what is the stage of the suit?
Stage of Lord, now Lord, it is going on, but should not be proceeded with for the reason that interlocutory application still kept pending. The application for substitution, Lord, that was taken up by your lordship and stayed.
Mighty, their injunction order cannot be stayed at this admission stage.
No, that is an ultimate order. When the order was passed by the London appeal court below.
I'm asking you, cannot be stayed.
No, I am not asking for that, below. I am not asking for that. That order cannot sustain. At that time, 2024, when the order was passed, at that time, suit as well as the appeal was
Without
awaiting.
hearing the other side, I cannot vacate the injunction order.
So your lordship kindly not to proceed with the suit.
Why?
In the then what will remain?
No.
What will remain?
Injunction order not to proceed with the suit, Miss Maiti. What are you saying? You are the plaintiff.
I am the
You should have prayed for expeditious disposal of
At
the
your
suit.
your lordship, very well, let him come to the other side.
The petitioner. Yes.
Your lordship, the application not contested, then it will
Motions, it
time your lordship.
so motions it cannot be done. Injunction, both courts, it has to be, it is a contested matter, Miss Maiti. Yes.
My lord, I'm praying for not today, my lord. Let Mr.
Not today, why?
My lord, let Mr. Surjarin Das, my lord.
On the prayer of the learned advocate for the
The opposite party number one. They served one notice asking to.
You are for the opposite party.
Opposite party number.
Pass over. Next.
I am applying all opposite party by instruction. I am praying for
Not only the execution cases there, but preemptive, I lost both the courts. But my ground, but I love to argue rather. But the Rajasthan Preemption Act. But
From Punjab, you have now gone to
now,
Rajasthan.
Now, Milord, it is admitted case that initial person, Milord, who was the owner, thereafter, Milord, the initially, Milord, one Sheikh Alauddin was the owner in respect of the plot number 807. Thereafter, Milord, the co-sharers of the legal heirs of the Alauddin, there was no, Milord, partition took place. Admittedly, undivided property. There were two transfers successively made by the legal heirs of the Alauddin wherein no, Milord, application for preemption is being filed. Relying upon, Milord, the Raghunath judgment, I shall try to satisfy before your lordship that even the similar provision is there in our Land Reforms Act also. There, the Honorable Supreme Court stated, Milord, after setting out the provision of loss of right of preemption, that also in connected to one transaction. Like Milord our, that yes, once transaction is being made, there are time limit for the Milord co-sharer, borgadar, as well as adjoining landowner. That similar provision is there. If you do not apply within that time, your right will be lost. Interpreting that provision of the Rajasthan Preemption Act, the Honorable Supreme Court said, no. If one person, one third party comes in and this right has not been exercised, successive transfer even to the third parties, you don't have any right, considering that it's a weak right. Because you are allowing third party to step into the property. Once that has been done, you are waiving subsequent blood transfer is being there, no right of preemption will open. That's the simpliciter case, paragraph 5 of my.
That point was ours.
I must be candid. But that was not. At least from the reflection of the judgment, your lordship will not find. But, my lord, this is something, my lord, which needs some deliberation. According to me, my lord, subject to correction by your lordship. My lord, nowhere, my lord, we are getting chance to argue this. My lord, kindly. Here out, my lord, I think, my lord, there are, my lord, I argued in one of the matter, my lord, before Justice Basu, but, my lord, that was not decided.
I think there are some judgments of our court on this.
Yes. 2005, Milord Justice Bhattacharya's judgment is against me. I will cite that also.
Asima Datta.
Yes, I will cite that also. That
Asima
was
Datta is
cited, Milord.
against you.
Yes. But Milord, 2022 Supreme Court, Milord, in my respectful submission, has interpreted the statute in some other way. Your lordship has to consider also
Provisions
whether
are
these are
perimateria.
perimateria or not. That also, Milord, I will argue. That I will argue, Milord, whether it's perimateria or not.
Yes, madam, what do you say?
kindly serve the
Yes, I will. Can I copy that?
fixed any date, ma'am.
Madam, hearing matter, preemption, it's just like an appeal, and you don't know what you will be arguing. We'll cite 4 Supreme Court judgments, 7 Calcutta High Court judgments. Because already he has started from Rajasthan. In another matter, he went to Punjab. You don't know how far he will travel throughout India. Mr. Mukherjee, only one thing, it's difficult because to hear this.
I love to argue that this point has not been argued, I believe, because this
thing, the time to hear this, that's the only problem.
that's up to your lordship. But if any date can be given, I can come and finish it off.
Specific date now might be a problem.
Very well, we shall argue. We shall mention the matter.
Yesterday, my lord.
Yes,
Parties are.
Only virtually, sir, my lord, no copy has been served.
only one thing.
And my lord, I am in difficulty. I have not get the material instruction as well as Bhokalatnama.
Only one thing. You can do one thing. What is there? I think today was the date or Monday was the date.
14th is the
Yes,
date.
14th, sorry. 14th is the next date.
He had sought adjournment.
Yes.
We have also sought for an
Yes.
adjournment.
So
Nothing is happening on
in that, Mr. Thakkar yesterday has pointed out in that letter you have mentioned that you have proposed 17th or 20th to 22nd or 23rd, whatever it might be. The date before the executing court is fixed on 21st, he said.
31st is the date fixed before the learned commercial court. It's a time barred section 34. I'm not going into it. And 14th is the date fixed before the learned arbitrator. Both parties, my lord, have sought for an adjournment written letters.
Only one
Written
thing.
not to hold proceedings on 14th.
On 14th. So,
nothing would happen.
according to Mr. Thakkar, the before the 34, it's pending on 20th or 21st.
21st for hearing of the section 5.
So, if you both of you agree to a date after 21st, I think
It's under consideration of before the learned arbitrator.
He has rejected.
Because, no, he's not
Rejected.
No,
That is the order.
no, there's no rejection order. Both parties have written, they have given a ground that they are
no,
34.
17 might be a problem.
17 is not there.
No, in your
17
letter
might
you have
come.
requested.
Yes, he has given
So,
17.
if both of you say that yes, you are agreeable to anything after 21st, I think that can solve that.
Section 5, my lord, is
If
pending.
it is there, I am not against that.
Yes.
Since according to him, he cannot, he will not be getting any opportunity to move his application. Maybe a
Nothing would
frivolous.
happen, my lord. Nothing would
Maybe a-
happen before the learned.
Maybe a frivolous application, he has to get a chance.
My lord,
Yeah,
the
he
cross
is getting a
examination
chance. My lord will kindly see the date, the minutes, my lord. My lord, we 3 sets of respondents, my lord, want arbitration. A claimant does not want arbitration.
No.
That's
That is
The claim is
Mr.
dismissed.
Doctor, that is another thing.
My
If both of you agree,
cross-examination is going on. Their matter will not be in
if
fact
both of
heard.
you agree to a date after 22nd, I think you have proposed 17. 3 or 4 days may not be a problem. Or otherwise, I have to consider this.
then-
That's the only
My
thing.
lord, only one thing we can make persuade the learned arbitrator to keep it anything after 20. That's
Sir, I am recording that.
anything. Let
Uh,
nothing be recorded, we will, my lord. I take it, my lord, I will make up a personal
Unless,
request to keep
so
it.
doctor, unless
keep-
something is on record, it
I
might be
will
a
make it, my
difficult
lord.
thing.
I will make a request to keep
I'm
it.
recording that submission that you will be, both of you will be making a request.
Let
Why only you? You will also.
I will also join me. My lord, I will make a request. Let
I will only record that, and I'm posting it after that. This matter.
Then,
Or it can be disposed of with that, Mr. Thakkar.
we will make a request, my lord. Let me come back, my lord. I will make a request to the learned arbitrator. My learned friend, senior friend who will also join me. We'll keep it any day after 21st.
Kindly keep
Because
this
if-
matter after 21st. Kindly
no,
keep
that-
this matter after 20th. Lordship will, I understand what his difficulty is. Client will say, why have you got it recorded?
Yes, because
I-
any order
we are on the
amount-
same side.
Yes,
So I understand what his
not at the
difficulty.
same side, opposite side. Can't.
Same side of the bar and the bench,
Yes.
sir. So any order, any recording of his whatever request he's saying he will make, that may have repercussions for his client. All that I'm saying, kindly adjourn this matter till the 25th. disposing even now.
In the interest of my client, I have.
My lord, if we may request your lordships to request the learned commercial court to dispose of the matter.
No, that cannot.
Request as expeditiously as possible.
No,
That is all. That is a
that-
request. I'm not
Let him-
fixing a timeline.
See the conduct, my learned.
Doctor, what is the difficulty on that date?
My lord, section 5 application is, my lord, they have done the mischief, my lord.
Let
Before,
it
before
dismiss.
section
Let it
5.
dismiss.
Do you have any objection in that matter being taken up on that date? I will only request. So I'm not saying that that is to be allowed. That is
No,
to be
no.
allowed in the-
Adjudicating.
Addressing the section 5 application, they are trying to move this stay application.
I'm not.
That was, my lord.
Take
they-
all possible pleas there. I'm not saying anything. I shall only record that since the matter has been fixed before the commercial court, I will request the commercial court to take up the matter. Anything.
My
Then
lord,
the CO can be
hearing is fixed,
disposed
my
of.
lord, for section 5. Section 5 hearing fixed on that day.
Yes,
That
I
is
am
all that
recording
lordship
only
is
that.
saying.
I'm recording that. I request the learned commercial court to take up the hearing of that application.
Well, then with that direction, let the CO be disposed of. Nothing remains in the CO, my lord. We have
CO is not against. My lord, I withdraw my prayer.
They have filed us.
Let
They
it.
have filed us.
Well, the CO is against the arbitrator, not against that court. That is why I made a request if they would agree. Otherwise, I am requesting your lordship to do something which is not within the domain of the CO. Only if they had agreed. They don't agree.
Let them be happy with something.
They don't agree.
They didn't get an award. Let them be happy.
So he is consenting.
No, not consent.
No, to take up only, not
Yes.
consenting with regard
But
to.
they will give me a copy. They didn't give me a copy. I didn't get.
I will give them a copy.
Copy of the 34, whatever.
Please,
34,
please,
36, yes.
34, 36, section 5, whatever it is.
Yes.
Please,
It
Mr.
appears for
Thakkar,
yours
please
for
ensure. And
Okay.
what is the date fixed for what?
21st for section 5.
Uh,
It is that extended.
at this stage, Mr.
I have to give him. I'll give him one day. I'm no
Give me a
missionaries of
copy.
charity. I will not do any charity.
Thank you.
Great.
for the response.
Municipality?
Yes. Well, this is finally comes to the rejection of the ad interim injunction. First quote, page 57.
57.
57. Heard no caveat. Contention of the plaintiff is that the plaintiff has been carrying on small restaurant business under name and style of Spice Den from the kiosk situated at the suite premises.
Any private party is there, Mr. Lahiri?
No, only one party.
Yes.
Pursuant to an agreement dated 5/9/2013 between the parties, plaintiff has obtained permanent certificate of enlistment which is in force till 22nd June 2029. The plaintiff further contends that on 22nd June 2026, the MLA of Bidhannagar constituency
Between the parties means between whom?
Between Bidhannagar Municipal Corporation and the plaintiff. I'll draw your lordship's kind attention to the particular agreement. The MLA of the Bidhannagar constituency visited the area with defendant, announced that all kiosk shops will be demolished without assigning any reasons or show cause. Apprehending demolition, the plaintiff lodged written complaint before the OC such and such to speed post. Accordingly, by filing the instant petition filed on the next date, suit was filed on 23rd. The plaintiff prayed for an interim order of injunction restraining the defendant from disposing the plaintiff from the suit property without due process. It appears from the document filed by the plaintiff that the validity of the agreement dated such and such was for 1 year, which may be extended for maximum period of 10 years, subject to certain conditions. So therefore, there is an extension clause. Also, the agreement mentioned that if any objection is received by any authority, the license will be withdrawn forthwith. It was also been mentioned herein that the defendant can cancel the license and agreement at any point of time during the period without assigning any reasons. Also, the kiosk should be absolutely temporary in nature and movable. This I have an issue. The agreement says that you cannot move without the permission. The plaintiff has not filed any document showing that the said agreement was extended after 1 year since its execution. Also, this court does not find anything which shows urgency of the plaintiff in filing the petition or that he will suffer any irreparable injury if the ad interim injunction is not granted in favor, since no document has been filed by the plaintiff in support of the basis of his apprehension that he will be forcefully dispossessed. That is my contention. There is no due process of law. Therefore, without giving the opportunity of money, so not granted ad interim. Now, thereafter, misappeal preferred. In the misappeal, which is the impugned order before lordship, same thing, but while doing so, Easement Act was extensively relied upon. Your lordships, I have, there are judgments that Easement Act is not applicable, but my lord, paragraph 8, 9, 10, 11 till paragraph 7, reiteration of the previous things. 8, 9, 10, 11
are the, say you have instructions.
My lord, instructions are it has not been demolished, my lord. But if your lordship, my lord,
sorry. Yes. On Tuesday they came for demolition.
Yes. My lord, till date it has not been demolished, my lord.
Yes.
But my lord, steps are being taken, my lord. Whatever is the my lord, illegal structure, my lord, has been because the agreement has also expired. I will also place the agreement before your lordship, my lord. My lord, these persons now cannot claim right till perpetuity, my lord. The tenure is over. It was for 1 year. Maximum period was 10 years. That is also over, my lord.
Where is the agreement? Are you ready with the instructions or you want to?
My lord, I have just received the brief. This is what I could gather.
So then, don't take any step. I can keep it on Monday or Tuesday. Please
I'll
take
take proper
instructions, but don't take any steps in the meantime. Shall I record your submissions with regard to that?
Your lordship will kindly pass a direction, my lord. That is always.
And my lord, what I'll be praying is that since we are in an ad interim stage, this has to be done before the learned trial court.
No,
this entire exercise.
No, Mr.
Let them appear there. It is
Lahiri,
law is
there are
settled. I'll be relying upon the judgments which says that due process. What will be the due process? Due process can be suit. There are judgments 1969. Your lordship has also held, and thereafter again,
I'm keeping it.
Building which has been erected is my property.
There are
Cannot be demolished like that. The entry was right. The building kindly sees. It was specific, my lord. I'm making him aware also. 1961 SC 1570.
So, where is the structure?
on the
Page 27. Kindly comes. Page 27.
it's adjacent to a footpath, my lord.
Yes, I'll show. I'll show. Page 27 is the agreement. Your lordship wants to see the structure.
All right,
Kindly
Mr.
come.
Rairi, let him take instructions because today you have moved. Today I have
Yes.
given you. So let him
He's
take
intact.
instructions because he's a.
Intact.
I've only requested you to give him who appears.
Yes, yes.
He has to take instructions.
He'll take instructions, my lord.
Yes, but please do not take any steps. I'm keeping it on Tuesday. This
Order,
matter was
sir.
mentioned. Solo tarik.
Item 9.
Item 9.
This cost there.
But Mr. Appearance, unless you record.
Yes.
That is what I'm saying. Consent, not.
Repeated occasions, the witness was not there. So the learned trial judge, my lord, got angry and imposed cost, fixed the matter on some other day. So, my lord,
So that is, I will not. Ashun.
only thing, my lord, it's the next date is on the 13th. On that day, they should.
Yes, 13th. Mr. Ghosh, no further adjournment on 13th.
Further cross examination on that.
Cross examination on that. Your witness will appear on that date. Absolutely. He is on the. This application That is why I requested him to serve anyone.
Why the learned judge was angry? Because my witness came from Bengal,
Madhur,
Andhra Pradesh, Satna. That is why.
That yes, because illness is
Illness. That is
also-
why I
and the nature of illness which Mr. Ghosh has cited, considering that, I thought that the more it should be.
that is why I said that it really should.
Not only illness is one thing, and he said pancreatitis. So the serious
That is
illness. Stomach pain, a severe stomach pain is one thing, but that ailment which struck me, that is why I asked him to serve.
There are matters where we should oppose. There are matters where we should grateful.
I am for the petitioner application for expeditious disposal. My lord, I am for the husband. My lord, in 2013, the petitioner filed a matrimonial suit. Thereafter, opposite party.
What is the miscase for?
For divorce, man.
Miscase.
Miscase.
Any proceeding for alimony?
Yes, section 24 filed.
Section 24, yes. What happened? Section 24?
My lord, that.
The section 24 application is to be disposed of fast. That has to be disposed of fast.
Yes, all proceedings are pending, my lord.
So let the miscase be disposed of fast. Thereafter, matrimonial suit.
My lord, there is 3 cases, my lord. Yeah.
What is the other case?
My lord, husband filed first opposite party filed section 24. Then my lord, petitioner is also filed a section 24 because both engage in a same business. My lord, opposite party filed on 3/9/2014, and the petitioner filed section 24 mid of.
What is the number of the miscase filed by the husband?
Case number 9 of 2015.
And wife is 32 of 2014.
Yes, my lord.
Both the miscellaneous cases are pending.
Yes, my lord.
This application under Article 2 Yes.
But I am for the petitioner. My lord, section 10 application was allowed in my suit, my lord, while the suit has not been reached into the trial in the stage of injunction hearing, my lord. The order, my lord, I have challenged.
What are the two suits?
My lord, originally there were 4 suits, my lord. 3 of them filed by the opposite parties. Out of that, one.
Here now you are claiming
Yes, my lord.
stay of title suit number 887 of 2025.
That is filed by me, my lord.
Yes.
Previously, 3 suits were filed by opposite parties.
Yes.
Out of that, my lord, one suit, my lord, was already decreed ex parte. In that suit, my lord, I was not even the party.
Which suit you are not a party?
In the first suit, which
What
I
is the
filed.
number of that suit?
That is, my lord, 1322 of 2018. That is in
Yes.
page number 31 of my.
That suit has been decreed ex parte.
Where I was not the party. Subsequently, my lord, 2 suits were filed by opposite parties for declaration of their ownership. One was filed in 2018. That is also not, my lord, reached into the trial. Another one was filed in 2023. That is also pending, not reached into the trial. In the suit in the year of 2018, I was made.
Where is your application under section 10?
It's not my application, my lord. They have filed the application because they are the defendant in the suit. In my suit, my lord, 887 of 2025.
Where is that application?
That is, my lord, in page number 116. Page 119 is my objection, my lord.
119.
119 is my objection. My contention is, my lord, this application is premature at this stage.
By the order impugned.
I have received an injunction in my suit. They preferred an appeal that was disallowed. Injunction order is in substance. Now, my lord, as it is stayed, all further proceedings, my lord, injunction order is operation of injunction order is also stayed, my lord.
Why?
My lord, as they are making submission before the BLRO, my
But
lord.
you are there, you have to apprise the court. What is the effect?
No, my lord, before the BLRO, because based upon the suit where they have
to make that order
no,
cannot
only
be stayed.
I
Stay of suit that cannot be stayed without hearing the other.
yes, I great.
Yes, next.
For the defendant petitioner. My lord, the defendant petitioner, my lord, he filed 2 applications, my lord. One application for, my lord, before starting arguing with your lordship, my lord, one thing I have to express, my lord, all the applications are made in Bengali language. That is why, my lord, I am unable to annex the
Why
application.
Bengali documents are not allowed to be annexed?
Sir, I have to translate in English. Otherwise,
Why?
because nowadays, my lord, the filing section.
Not accepting.
No, man. This is the whole difficulty, man.
Not accepting money.
All documents.
They ask for translation.
Well, the entire documents are in Bengali language. To
You have a copy of those
yes,
applications.
everything I have, madam.
Yes. What is this matter?
Well, a suit for recovery of khas possession, permanent injunction, and cancellation of sale deed filed by the opposite parties plaintiffs. My lord, thereafter the petitioner, my lord, he contested the suit accordingly, my lord, and thereafter one application filed by the opposite parties for expert opinion regarding the LTI of the plaintiff number one, who execute the sale deed in favor of the defendant, my lord, in favor of the defendant petitioner. In 2001, that sale deed, it was executed and registered in 2002. In December 2001, it was executed and got registered in January 2002. And in 2010, the same plaintiff number one, well, she made a gift deed in favor of the other plaintiffs who are the daughters of the plaintiff number one. And thereafter, till that time, my lord, the petitioner, he is in possession, and that time he was in possession, and he runs the jolkor, the fishery, over that property, my lord, and he is taking the money, my lord, for getting the fisheries, my lord, and he he corrected the record in before the BL and LRO in his name, and accordingly he mutated his name, my lord, and he.
What is this application for?
Well, there are two applications filed by the petitioner. One is maintainability of the suit, my lord, as the suit value of as the value of this sale deed 1,20,000, but the suit filed before the junior division. After the change of advocate, my lord, going through the records, well, then the application for maintainability ground, it was filed by the petitioner, and at the same time, one application challenging the.
Give me the plaint.
Yes, my lord. I have to step back to the.
You said the suit is for cancellation of the deed.
Yes, my lord.
Where is the prayer for cancellation?
I have not filed. They filed the. Prayer go, man.
Oh,
Go.
no, cancellation has not been prayed
Yes,
for.
only prayed that this is a fraud.
Fraud, not
But
binding.
yes, but not
Cancellation,
it is not
cancellation has not been prayed for.
yes, not
Then
executable. That has not specifically prayed.
if that is not, plaintiff can put in his own valuation.
But I'm not on that, my lord. On the
Then
application.
it's within pecuniary
Yes,
jurisdiction.
well, that application was rejected. But on the same day, that is on 21st July 2025, two applications filed by the petitioner. One is maintainability ground and another is challenging the report of the expert opinion.
Challenging the report. Expert has filed a report.
Yes, but the report is not here, my lord.
No. Where is that? Please show me from the impugned order that expert report was accepted.
It was not accepted.
Then
Nothing is there, my lord, in the order.
no expert here only the maintainability issue was decided.
Yes,
Pecuniary
that
jurisdiction.
application has been decided whether both the applications were taken together, and on that day, my lord, when the impugned order I have challenged both the applications for the maintainability of the suit and the
This sale deed was executed by the plaintiff
plaintiff number 1 in
in
July,
favor of
the defendant petitioner.
where is that decision? Surit Singh.
My lord, may I come back with the decision on the next date, my lord, with the report also.
What report also?
The expert opinion report.
Not expert opinion, valuation.
My lord, I shall.
Where is that?
It is not with me.
Just Mr. Ghosh, Surit Singh. Decision. Cancellation. If it is by the executant, it has to be on the full value.
And may I come back on Monday, my lord, with the judgment?
Still. You have not prayed for cancellation. That's the other difficulty.
They have not prayed for us.
Yes, so then if it is not prayed for, why it will be valued at that? The suit might fail. They cannot be asked to amend that valuation.
But my lord, the ultimate.
If you want, please come ready
Well,
with that judgment. I think that will not help you because the suit might fail. But
another thing is my second application.
second application has not been dealt with.
But hearing was completed, my lord.
So let the order be passed, then I will consider.
Well, but the cross-examination of the dependent petitioner fixed by the learned trial court, my lord, in the meantime. That is the difficulty, my lord.
That is the other thing.
My lord.
No, this is not the handwriting expert, not pen proof.
So both the applications are there.
They are saying that they are accepting.
Then my lord, I shall file a supplementary affidavit.
Supplementary is not necessary. Only thing what they are saying is at the time of affidavit, that oath commissioner, that there is a stamp which is saying without translation. That you are not doing. If that is done, they will accept. No, the stamp is to come from the oath commissioner, that is without translation. Yes, Mr. Rai.
Sometimes.
Mr. Mukherjee.
If the commissioner put their signature without translation, then it will be go. If it is not the vernacular language, is there is no indication, then it should be along with the translated copy.
You have to tell the commissioner that
Commissioner is to put the signature seal that this
That information was not with me at that time.
this petition has been affirmed without any translation, or without any translation, that seal is there.
তাহলে করছেন তো
Certified copy handwritten, one thing there handwritten, a certified copy of the order impugned orders. They are to be typed. It is the order of this thing for otherwise they will not.
No, only thing, Mr. Wright, yes, if it is not very
Type
legible,
copy. Those are not the impugned order, but when it was obtained, another 2 or 3 handwritten orders are there. This is all the handwritten orders are typed. Well, they are not accepted. Whether it is
Expeditious ক্ষেত্রে
order adjournment like that. Those are 2 typed colors.
yes, madam.
Then my lord, I shall
Yes.
come back with the judgment and
What you will come back? Judgment will not help you, madam. Cancellation has not been paid for here.
but that point has been taken in that application of non-maintenance.
This is Mr. Rai, you are appearing in this matter.
No. Chance my lord, on Monday I shall come.
Not today, He's doing photocopy of this. পেনটা কি দিয়ে দিলাম না এখানে? Please bring those photocopy of those.
I shall.
Yes. Call the next matter.
I have concluded my submission.
Yes. So Bhattacharya will start. Till he comes, I will just.
How much time we will take? Because today we are short of time.
Mr. Bhattacharya told indicated yesterday that he will take 40 to 45.
Today I cannot continue after 3:20.
It will be a
keeping it Monday.
Monday. As your lordship. Then your lord.
Oh, not Monday. Monthly list. Tuesday and Wednesday.
As your lordship.
Whenever you call
Both
for it,
are
Mr. Bhattacharya, you said you will be taking 40 to 45 minutes. Today we are I have to rise because that's the full court is there. So 10 minutes. Monday is the monthly list. If you want, I can put it.
CPM it will be taken up.
Monthly list ছাড়া বলবো। Order to Tuesday, 4 p.m.
There are even if there is a 3:30 minute, it is deemed that 4 p.m. it will be taken.
Tuesday 3:30 will be there.
Mrs. Banerjee
Yes, ওই টিউসডে করে দিন। কিছু অর্ডার করতে হবে না? টুটে করে না। Yes, yes, yes.
No, for Mr.
Call the next matter. Dakun. 37, yes. 37 কেন? 33 তো। কেম আছে?
My lordship, I'm for the petitioner in item number 37.
তুমি কোথায় 2 PM?
Well, I am available
We
on.
advocate agree for the opposite party. First up, Mr.
Good.
Next.
But it will mark as 3 PM.
Milord, may I kindly
This position means, Milord, it's quite a down in the list. Because of
may I
the
kindly
marking,
ask
Milord,
once,
the supplementary list of the monthly list.
Mr. Chatterjee perhaps, Milord, is
Milord,
online.
may I just ask once, Milord, your lordship has fixed it on
I've kept it, written its position in the list.
on Monday, Milord?
Milord, as 3 PM.
Monday it is appearing.
Monday, Milord, is the monthly list.
It's in the monthly list or the supplementary list?
Supplementary list.
Supplementary list, except Monday, Tuesday or
Mr. Bhattacharya's matter, your lordship has just fixed. So he says he takes about 45 minutes.
45 minutes on Tuesday. He's not on
Wednesday,
Monday.
your lordship fix it?
Wednesday.
Wednesday.
Let me see. Let it appear on Monday.
Very well.
Yes, call the next one.
Yes. Regarding the Milord, that jurisdiction, ordinary
Yes,
residence.
yes, Mr. Rai, what do you say?
His document it will appear. I'm not on that, my lord. May I hand over subject to my lord's agreement? A copy.
One thing, Mr. Rai.
One thing, my lord, keeping aside everything, my lord, I'm not on that. Whatever the child goes, it একটু জজ সাহেবকে দেবেন. This is a child. Hey.
What is this?
This is the communication between the husband and the wife. Last portion. দেখে না কোনটা এটাই তো এর আগেরটা দেখাচ্ছিলাম এর আগেরটা এর পরে ওটা দেখাবো এই হ্যাঁ এটা বড় করে দেবে তোদের এইসব হ্যাঁ এই তো না এটা বড় করে দেবে হ্যাঁ
So it can be sorted out.
Yes, that is what besides on the earlier occasion, I also informed my counterpart also.
Can be sorted out. That's what is this?
This is a WhatsApp chat between the
page,
wife and husband. That is what I
wait to Mr. Go.
Shown to my
এটা দেখানো
hard copy. I will give the hard copy because I have already translated copy.
The last portion which says
this can be solved just by us. Because I also impressed my client that going in because ultimately, my lord, the child is.
First, please consider one thing.
Your lordship can see here. He has said that and get her to the most comfortable place such and such. This is why.
If the parties want to solve this problem outside the court, I think this should be.
It goes to be the.
You are there, Mr. Ghosh. You are the senior most person.
Yes, that is what.
All those who are appearing. So please sit with your client. If after all, it's the question of a welfare of a child.
Yes.
So since you are there, all of you can sit together, ask your.
I'll not invite my.
Because if this issue can be sorted out, once for all, it's sorted out. Otherwise,
it
can be decided. There is no difficulty on that. So Mr. Rai has shown me this. You can also take instructions.
No, I have also informed my counter.
Because after all, Mr. Ghosh litigating with a child.
I will
Mr.
never
Ghosh,
I will not.
that is why, since you are here and you are the senior most person,
that can be done.
please
But
you take the responsibility because
yes,
both
you
of
can take instruction of this chat also. I am giving you the hard copy. So
yes, please take the hard copy. Please ask your client because
my lord,
it's better if the parties sort it out.
Yes. The parties yes, fight. That is so it can be done.
Because it's a question of the.
But as see, surreptitiously took the child from here. That's why.
Now,
and thereafter got an injunction.
Forget about that. If it is not solved, if it comes to the court, decide it one way or
always
the other.
welcome. It is always welcome. You'll not.
So that is why if it can be settled, considering
at the initial stage, now it is at the initial stage. Still, there is communication between the wife and the husband and the.
Yes, and that is also very important, Mr. Ghosh, what Mr. Rai says, because the proceeding has just started.
Yes.
So if it can be, it can be sorted out at this stage, it's better. Otherwise, if the litigation proceeds, something there, something, and some orders, so the parties will be at loggerheads.
Then not if you also find that this court has no jurisdiction, then it will go to that court.
Then again,
let us similarly.
That's one way, and there is on merits.
Yes.
If it is a contested, some orders will be passed, some will challenge. Then bitterness will again come.
No, let us.
I think it's
let us see. Two mentions of if my learned friend is that matter will go out. Let us see. একসাথে তুমি মক্কেল এবার বসে নিয়ে ঠিক দেখো আমার কোনো ইয়ে নেই আমাকে Twenty 26th what or 25th my lord 26th whatever is the কি হচ্ছে
জুলাই
কি আছে কি হাসছে কেন কি হলো
Can it be made in the first week of August? You have said 20.
Yes, no, that
7th or 28th July. Can it be made in the first week of August?
As your lordship pleases. First of August, not in the meantime, mother so that mother will visit. Record that mother will visit. Mother can visit.
Mother will visit.
Yes.
It's where?
In
where?
পড়বেন না এখনই that is why in the mall any mall
where is the place? Do it fast, please do it fast.
কোথায় থাকে কোথায় all my lord it will be my lord pass that order কি আছে
Well, I'm recording that you do not.
Yes.
When this matter is taken up for hearing. there. He's saying,
My lord.
please,
Yes,
fix
Lord.
the date, a place, neutral place. Please
Yes,
tell.
yes.
Mr. Rai, please see that that is.
I am also impressed by client. It is doing fighting between yourself will not any benefit to the child.
All this
It is suffer.
child should not be made.
You can fight, you can die.
List this matter. Customer se comment.